Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing. What is the basis of your request for detention continuing today in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? It doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in charge of who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
I can quote one decision on this. Understandably, the decision that Mr. Omari has referred to the court to, if I got him right, is a decision of number 96 of 2011, Your Honor?
93.
93 of?
2011.
2011. So, is my good friend, he may not have seen what Honorable Justice William Musyoka says in Dennis Rosanna Manyibe.
Could you give us the
I will give the citation. We didn't know you'd raise the inquest.
We don't raise. So, just give the citation.
Your Honor, Dennis Rosanna Manyibe and 4 others versus ODPP and 2 others. The good judge is not only an authority in law of succession, he delivers a beauty of a judgment. The citation of this case is Kakamega Criminal Revision number E001 of 2022. E001 of 2022. And basically what the judge is doing is the nature of inquests in post-2010 Kenya. And I'll read one paragraph. This is what he says. I quote him, "The first is whether it was necessary," which is what Mr. Omari is telling you, "in the first place to conduct the inquiry in view of the letter by the first respondent, the ODPP. The purpose of conduct of inquest proceedings is to primarily determine the cause of death, particularly where it is suspected that the same was by hand of another. Where the persons responsible for the death are known, there would be no need to conduct an inquiry. The suspects ought to be arrested and arraigned to answer to a charge of either murder or manslaughter or any other related offense. The inquest will be conducted where there is doubt or where the possession is clouded in some mystery for the court to unravel the mystery. Where there is no mystery or the circumstances are fairly clear, then the first and second respondents need not ask the court to conduct an inquest." Now, this is part of the law on inquest post 2010. There is a similar decision by J.V. Ojwang. He was a judge by the time. He rose all the way to the Supreme Court. And the decision which I would invite the court to have a look at is Nisha Sapra versus Republic. This is way before the Constitution of Kenya 2010, but it still has the same principle. There's also the decision of Honorable D.S. Majanja J. May the Lord God put his soul in eternal peace. In re-estate of Philip Otieno Odhiambo. Re-estate of Philip Otieno Odhiambo. This is reported in 2015. And finally, on the question of inquests, one of my favorite judges, Justice Mongo, my phone has just gone off, Your Honor, but I'll provide Justice Mongo's decision.
Help us more knowledge. You know we are students. In those decisions, where was the scene of the death? Just tell the learned.
All right.
Only that.
Mr.
Sorry, Your Honor, we will not answer that.
Owiti, you've made your point, and actually, this case of Misha Sapra, I'm
Yes.
familiar with it.
Thank you very much, Your Honor.
Let's not focus more on the inquest.
I am done with the
because
point.
The substratum of this issue is the
Thank
pre-charge
you.
detention.
Thank
Let's just focus on that.
Thank you, Your Honor.
Yes.
I am well guided.
Yes.
Actually, that's why I started with it first. We are done with the question of the inquest. Now, Your Honor, I wanted to read for you the decision of Titus, the Court of Appeal decision on Titus Ngamau, but because my phone is off, I'll just ask them to get it for me, because I think we need a point of reflection in this matter. With a lot of respect, I think the defense have treated this matter with some lack of seriousness, with a lot of respect. And that's why you hear questions like, release him on a bond of 7,000, release him on free bond. This court is bound by section 60 of the Evidence Act, and this is 60 subsection 1 subsection O, to take judicial notice of matters of public notoriety. Judicial notice of matters of public notoriety. This court is human and does not live in vacuum. This court has eyes. You can see the number of media officers here. You can see the number of Kenyans in court today. This matter cannot be treated with a lack of seriousness. And what is the matter? The matter is that we are saying a Kenyan died in a Kenyan police station. That Kenyan is identified as Albert Ojwang. Of course, we are both Luos, but that's not why I'm making this argument. True. And that is a disclosure of conflict, possible conflict if there was. There is also admission from the defense that the person sitting as the respondent before you is the OCS. While they had questioned it in their affidavit, they have admitted severally. And not just the OCS, is the OCS of, according to Mr. Prosecutor, one of the greatest stations in Kenya. And that is not enough. According to Mr. Omari, he has been in the police service for 29 years. Now, with that point of reflection, just before I get to the decision of Titus Ngamau Musila Katitu, a police officer who has been in service for 29 years, who else would have more influence, either on witnesses and or the investigations? And with that point of reflection, allow me to just read paragraph 1, because the Court of Appeal, this is what the Court of Appeal says in the decision of Titus Ngamau Musila Katitu versus Republic. This decision is delivered on 24th April 2020 by Justice William Ouko, may rest in peace, Fatuma Sichales, and William Ouko, I withdraw that, Fatuma Sichale and Ole Kantai. And this is what they say. This is why it is hurting me at this point. The blue code of silence, which we are being told not to talk about, is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. Kenya is part of Africa. You allow me to just read this. It is the unwritten rule according to which police officers never provide incriminating information about their colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. The offense we are talking about today is the offense of murder. There is no greater offense leading to self-preservation than the offense of murder. We admit that all offenses in Kenya are available, but there is no greater need for self-preservation where a police officer, no less than the officer commanding the station, is intended to be likely charged with the offense of murder. A feeling of esprit de corps among officers who by and large depend on each other for their very risky lives as they confront the violent and hostile world of policing and crime. This background is important, and I hope it is also important to us today in our consideration of this appeal, because the police in Kenya, as we shall demonstrate, the three judges are speaking, as we shall demonstrate in this case, as in others before it, has in certain circumstances engaged in the practice of covering up for each other. And the court proceeds to give examples. So that we are saying, when we say that the respondent before you is likely in the act of self-preservation interfere with ongoing investigations, we are not plucking it from the air. There is basis of it. The Court of Appeal has seen it before. Now let us go back to the, yes, I hope the court will have an opportunity to look at the other parts. Let me go back to the application so that we get back the court to our application, because we may have lost what we are asking. And Mr. Kangai did a good job in referring you to the orders we are seeking. Your Honor, the limited order in prayer number B is that the respondent be remanded at the Langata police station or any other police station within the Republic of Kenya as the investigations may dictate, to enable the applicant conclude investigations. The main primary reason why we are asking to hold him is to enable the applicant, IPOA, complete investigations. Now, there are very few questions which are necessary to contextualize. Is Albert Ojwang dead? Yes. Did he die in a police station? Yes. Was the police station Central Police Station in Nairobi? Yes. Is the respondent the officer in charge of that station at the material time? Yes. Has the IO informed you that investigations are ongoing? Yes. His affidavit evidence has not been contradicted or controverted. There is no denial that there are investigations. Coupled with the public interest, even as we presume the respondent innocent, would it be in the interest of the victim? We have seen, just like them from social media, the father of Albert Ojwang confused, running across Nairobi. Is it in his interest as the victim and his family that the respondent should be released on 7,000 or free bond? Because the rights belong to who? Accused persons. And our answer is no. Your Honor, we are at an investigation stage. A decision may, most unlikely, but may still be made that the respondent in the dock is not to be charged. The decision to charge him or not has not been made. We are asking you, because of the complexity of the matter and because of the blue code of the police, which has been judicially noticed by the Court of Appeal of this country, allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that our approximation as per now is that 21 days will do justice not just to us, but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1) G and Article 49(1) I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1) which requires at first appearance that he be charged or informed of the reason for his detention or to be released. Once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed, in my view, in my very respectful view, is that the threshold is met once the reason is given and it is satisfactory to the court. The arguments about compelling reasons, arguable reasons, are reasons which are better still placed on arguments for bond pending trial. Let me hit the last point, which is apprehension vis-a-vis likelihood. I have had Mr. Ompeta, who I respect so much because the decision in Dwight Sagerai is one of my best read decisions in this country, tell this court to ignore the bail and bond policy guidelines Although he said it in passing, but that was very unfortunate in my view. Because the bail and bond policy guidelines is intended to standardize the application of the law on bail and bond in Kenya. And if I get it right, I think it is clause 4.9 of the bail and bond policy guidelines. The word likelihood is used at least 3 times, so that the likelihood to interfere with investigations is a sufficient ground, even if we were arguing bail pending trial, to deny bail. But on this lower threshold of a balance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I humbly pray. Thank you very much.
Defense conceded to prayer 2 and granted access of the phone to a Paul. The handset was taken by the investigator on the date of arrest. Other than the investigator and the owner of the phone, none has access to the operation of that phone. From yesterday, that same number of the OCS, it is number, that same number, Your Honor, the OCS, that is the respondent, 0722 91 98 80, has been sending messages soliciting for money.
Allegations have been made, which we are not ready to deny or confirm.
Okay.
We confirm that a phone was taken from the respondent. Considering the nature of those allegations, and having heard what Mr. Langata said last, without the attempt to impugn bad motive on their part, because he's already talking about the integrity of the custody. As we speak now, we believe and we have no reason to doubt that the phone and any other exhibit in relation to this matter has been properly kept in safe custody in line with the dictates of chain of custody. We have quickly, as a preliminary issue, texted Mr. Jibril.
Okay.
He has responded that no one has it switched off and it's in the lab.
Okay.
I have no reason to doubt, just like I have no reason to doubt them, I have no reason to doubt Mr. Jibril, that the phone was switched off immediately it was taken from the respondent and it is safely kept in custody in a lab. However, Your Honor, we would humbly advise our colleagues through the court that they make a report, because these are serious allegations, so that let me just finish. If you've done that, that's okay. That's a good way to deal with it. So that separate investigations can be undertaken on that. But Your Honor, just like I mentioned earlier that I'm a student of common sense and the law, it beats logic that a senior investigator in the level of Mr. Jibril would request for 80,000 using the same phone of the respondent. But because I don't want to impute bad motive on their part, even though it beats common sense that an investigator can ask you for 80,000 and ask no one else, ask the counsel for the same person. It beats.
There are a number of messages. There is 45,000 for another person. There are quite a number.
That's right. I am saying that.
And also cancel. We are not imputing the problem.
Let me just finish. Let me finish.
We are saying a non person, not Jibril. We
Yes.
know Jibril is a good man. He's an advocate of the
Let me finish. What I'm saying, Your Honor, without doubting my colleagues and without doubting the IO, is that it would beat common sense for whoever it is to take, for such a public interest matter, the phone of a respondent in the level of the OCS and request his counsel, among many others, his counsel for 80,000. So we ask them to report. Let us have investigations into that matter, so that the truth may come out. We could have a mention date.
Okay.
If there is need be to bring the investigating officer. I don't think we need the commissioners of IPOA to come and tell us that the investigating officers kept a phone, because operationally it is the investigating officers who are in custody of the mobile phone.
So I think it's a very serious allegation.
Yes.
Miss Christine.
Yes, Your Honor. Yes, it is serious.
Yeah. Because already they have undertaken the first step of reporting, yeah?
Yeah.
So what we can do,
Yes.
it's been a long night and a long day, yeah?
Yeah.
Let's take a mention date, yeah? And then we can summon the investigating officer, Mr. Jibril,
Right.
yeah? To shed light, because, you know, through, I understand he has communicated through a message.
Right. Yes.
Let's take a mention, and then also they should follow up on this, yeah? Because, you know, as a court, we cannot investigate
That is